All right, welcome back. We're still in chapter 2 of the book, which is the relationship between constitutional law and administrative law. We looked at a bunch of more kind of basic issues last week as to how administrative decision makers are bound by the charter. We said oftentimes it means that either they'll have to apply the charter in some way, and we also said that they need to do that oftentimes when it's a matter of applying procedural fairness protection. So they'll either decide on the constitutionality of a provision, or there will be some sort of procedural fairness protections that will apply by virtue of the charter. We said that there's distinctions between courts and administrative decision makers in applying constitutional law. We said that there's limitations as to what administrative decision makers can do, both by virtue of the authority that they can be delegated, but also by virtue of their unique role. And we said generally the remedy is one of the things that's always different between courts and administrative decision makers. And we said that administrative decision makers don't have the power to make a general conclusion of constitutional invalidity, right? So they can find that a statute is not constitutionally compliant, but they won't declare it to be invalid to the extent of the inconsistency as a court would. Instead, they will decide not to apply the statute in the specific case because it's the only thing they can do. And so it means that in the specific case, right, it's as if the statute had been invalid, statute or provision, but it's not going to apply in future cases. It's kind of similar to another principle that we saw, which is that administrative decision makers don't really create any case law, right? So we said that future administrative decision makers are never basically bound by the prior decisions of other administrative decision makers, and that's in contrast to what we'd see in the court system. So we're still again in chapter 2. A couple things that we see in this chapter as to how administrative decision makers make these decisions differently, and then we look at the various provisions of the charter sequentially, looking at the tests for each provision of the charter in a very summary fashion, and then subsequently how that applies differently, specifically in administrative law. So first thing that's mentioned in the chapter is section 24 of the Constitution of the charter, which provides for the ability of a tribunal defined broadly to be awarded damages under the charter. And we said that that's not usually the remedy. So if a statute is not constitutionally compliant, typically, as we said, it will be invalidated to the extent of the inconsistency by a court, say, and that's generally going to be it, right? The person is not going to get damages, and generally they're not even seeking damages because they know that that's extremely rare. So if you go to court might find that one of your very important rights was completely infringed upon by a statute. For instance, your Section 7 rights say to life, liberty, and security of the person. And the court will have a remedy that is in line with that, generally striking down the provision or the statute. However, the court generally will not award damages. So even though by virtue of the fact that the court's found that way, your rights have been infringed for a relatively long period of time, right? And ostensibly, that's also true for all similarly situated people who were subject to the same statute, had the same infringement. The court is not going to award damages generally, even though it recognizes that your rights have been infringed. So kind of different from other areas of the law. Usually when people violate your rights or your privileges, you get damages for that. You can ask for damages under Section 24 of the Charter, which gives the power to the court to award damages. Decision maker broadly, to award damages for a violation of the charter. As we said, Generally, that's rare, and that's because there is a presumption that the government, if it is acting in good faith, is basically not going to be subject to a damages award. So the government passes a law, generally, right, does not intend for it to violate constitutional rights, right, doesn't set out to violate charter rights. And to the extent that that's the case, the government's not acting in bad faith, and therefore there is not going to be generally an award of damages because the government has basically violated significant constitutional rights, but done that in good faith. So how do we decide whether or not Section 24 applies? One of the important things to remember is that the administrative decision maker has to have the authority to make that decision in the first place. So if, and this is pretty intuitive, right? If you ask an administrative decision maker for a Section 24 award of damages, the first question is not whether or not they can award damages. The question is whether or not they can apply the charter in the first place, right? Because that damages award pursuant to Section 24 is related to a charter infringement, which the administrative decision maker has to have the authority to declare in the first place. And we looked at that, I think, last week, right? We said there's various ways in which an administrative decision maker can have the authority to make a constitutional decision. We said usually it is express, but express is kind of misleading. So can have an express grant of jurisdiction to do that, but usually that will be by virtue of a general phrase that says something like any law. So the administrative decision maker is allowed to apply any law. And any law includes the Constitution, which includes the Charter, because it's a law, right? And that counts as an express grant of jurisdiction, even though it doesn't say the words Constitution or Charter. We also said it can be implied from kind of the structure of the tribunal, which we looked at last week in a bit more detail, and we said that will vary. That will vary depending on the type of tribunal, and it's an indirect way to, again, look at the intent of the government. Usually it will be express, right? And so if the statute says the administrative decision maker has the power to apply any law, that includes the Charter, and that also includes Section 24 of the Charter, so the decision maker will be able to also award damages pursuant to Section 24. There's a discussion of jurisdictions, pages 88, 89. I won't go over it in that much detail, but basically you have to have the requisite jurisdiction, which usually is the same for Section 24 and the rest of the Charter. Page 90, 91, you have the test, which is kind of important, right? But basically the claimant, the person looking for charter damages, has to establish that damages are appropriate. And generally that will not be the case when there's an appropriate alternative remedy, right? Such as judicial review. And there's also that presumption of good faith, which is mentioned and which I also mentioned earlier. Then there's a discussion of charter values, which is a pretty confusing concept. Basically what it says is that, what it means is that when a decision is made, and usually a decision that's somewhat discretionary, there is a potential to infringe upon a lot of charter rights that are often not directly engaged and that therefore need to be balanced. And so if you have a minister who has the power to say, the discretionary power, meaning that they exercise it as they please pursuant to the statute, the statute says that. Statute says right? The minister will exercise that power as they see fit, right? That wouldn't be the actual language, but basically that's what the statute would suggest. Then the minister can't just do whatever they want, right? Even though it's discretionary, they have some discretion. They still have to respect some stuff, which includes procedural fairness protection. So they can't start discriminatorily exercising that prerogative, and they can't start exercising it in a way that's unfair to the procedurally to the person that they're making a decision about. In making that decision, they'll also have to consider certain charter rights that are not directly infringed. So for instance, you might have a government creating, one of the examples you have is a course on religion, and then the government is going to have to weigh implicitly the competing charter rights, quote unquote, they're not really rights, of freedom of religion and, say, freedom of expression, or freedom of religion and freedom to be and being free from discrimination pursuant to Section 15. Then, when the government makes that decision, there is no right that's infringed because the government is creating a program, right? And so that program doesn't exist, and therefore it doesn't infringe upon constitutional rights yet. Right? When it does, then someone can sue. Someone can say they have a live interest, which they have to sue. They have to say that their personal rights have been infringed, right, individually, and then they can go to court. Program doesn't exist yet, that doesn't happen. Nonetheless, you'll expect the government to make that decision in a way that weighs competing charter values. So charter rights that have yet to apply as actual rights. And that's what we expect of the government, and that's a reviewable decision. So if the government does not give proper regard to the interest of religious communities in making that decision, which has a constitutional value, then that decision can be reviewed by the courts as essentially an administrative decision. Sorry. Of course, that will be subject to usually reasonableness review, which makes sense because it's not, right, from that broader that broader framework that we discussed. We said reasonableness is more deferential, and usually the reason we allow for there to be more deference is because it's the intent of the government, and usually it's not something that's too bad to decide about, right? Like we wouldn't allow reasonableness for decisions of statutory interpretation because they have a broader impact on the law generally. We wouldn't allow that for significant procedural fairness concern, right? Like taking away someone's liberty or someone's life indirectly by, say, sending them to some other country to die. So charter values not being charter rights, not that important. It makes sense for that to be subject to reasonableness review because it's not as concerning. Yet, of course, if it's a matter of validity, then it's going to be correctness review, of course, right? So if the administrative decision maker says that a statute is not constitutionally valid, which we said they can do if they have the authority and all that, and then once they make that decision, as we said, the proper remedy applies, which is to not apply the provision, as opposed to strike it down, right? I'd shed that. When that's the decision that they're making, it's subject to correctness review because it remains a serious decision as to whether a statute infringes upon the charter and not a charter value, but a charter right, which is more important and stringently protected because it's an actual constitutional right. And that decision, as we said, for the actual person that's before the decision maker is the exact same as if it were made by a court. So if it were a court, the statute could be struck down, but for the individual claimant, it doesn't make a difference, right? For the individual claimant, the result is the same, and therefore the potential serious impact on their life is also the same. And all of that is pursuant to two precedents, which you will want to remember, which are Doré and Vavilov. Vavilov being the one that set out the entire standard of review analysis that changed in 2019 and which we're studying for this entire course. Doré is another case about essentially charter values. What happened there, you had a guy it was a lawyer, wrote a very mean letter, I think, to a judge, and then it was a matter of whether the bar properly exercised its discretionary power to intervene in that case. So that case was important because it set out the standard of review for more discretionary, quote-unquote, charter values decision under the charter. The other thing that framework says is that that there is essentially a spectrum, we'll call it, of protection, which is important, right? And so the seriousness of the decision will be relevant in that weighing of whether or not you can infringe upon charter rights. So the government's allowed to basically weigh the potential charter values that are at play with the importance of the statutory objective that is trying to achieve, and therefore, right, decide whether or not it's essentially worth it. Kind of like what we'd see under Section 1, because Section 1, essentially essentially means and proportionality analysis, right? Basically looks at how bad the infringement is, how serious the purpose of the law is or what it's trying to achieve, and weighs the two to decide whether or not it's an appropriate balance. I think we'll try to stop there and for a little virtual break.